I mentioned Lloyd Cutler was the youngest member of the prosecution in 1942. Mr. Cutler wrote an op-ed in December 2001. It was a month after President Bush signed the order authorizing military commissions. It was about a week and a half before the first detainees got off the airplane at Guantanamo Bay. And his op-ed was in the Wall Street Journal, and Mr. Cutler reflected back on the lessons that he'd learned 6 decades earlier, having participated in the trial of the 8 Nazi saboteurs. He said the Bush administration should allow the accused access to the federal courts. They should minimize secret proceedings and make it as open and transparent as possible, and that each accused should have a right to competent, conflict-free representation by counsel of the accused's choice. And he concluded his op-ed by saying, quote, "In a very real sense, it's the American legal system, not just al-Qaeda leaders, that will be on trial." Mr. Cutler passed away a few years ago, but I think if he was standing here today, 9 years after he wrote that op-ed, he'd say the verdict is not pretty about the American legal system and the way it's handled the detainees at Guantanamo Bay. If you look at the way this has worked out, as I mentioned, the Bush administration saw this order from 1942. They saw a process that ran its course in 43 days in secret. And I can tell you, having been chief prosecutor and talked with some of the officials that were involved, they were shocked that we weren't able to get this, the military didn't jump in and get this done in secret and quickly and it would all be over and done. The people objected. Like Colonel Royal. Remember Colonel Royal, the order said he couldn't go to federal court and he went all the way to the Supreme Court. Charlie Swift did the same thing in the Hamdan case. If you compare the Bush administration's record in court with the detainees' record, and as Mr. Wilner can tell you, they've had a pretty good record in the Supreme Court. From Hamdi to Hamdan to Boumediene, the detainees have won. I was looking at SCOTUS blog today, and if their numbers are right, there have been 38 habeas petitions that have been reviewed. Detainees have won 29 out of 38. Now remember, is that not right?
It's not correct.
What's the...
It's
38, 19.
Well, it depends how you count the Uyghur cases, but it's with the Uyghur cases, it's probably 38, 18, without 36, 18, something like that.
No,
without
no.
the Uyghur cases.
No, wait a second. It's well over 60%, 70%, so it's not 50% wins. It's well over 70% wins. If you could put the Uyghurs in, yeah.
Yeah, that's what I just said.
No, but you said 36, 18. That would be 50%. I think it's 36, 22 or something. I mean,
Yeah. Okay, well,
70%.
Somebody can Google it in the audience.
yeah, I guess the point I was trying to make here is, remember, these were the men that were the worst of the worst. You know, the hardcore criminal terrorists that would chew through the hydraulic lines on the airplane in order to kill Americans. Yet, at least 50%, judges have concluded, not just a judge, but
we agree. He said 36 wins, 18 losses, so 2 to 1.
Those are round numbers.
Yeah,
Right.
It's
2 to 1.
2
Basically.
to 1. 2 to 1.
But again, if you
Yeah.
accept Donald Rumsfeld's statement that these are the worst of the worst, the hardcore terrorists that would do anything to kill Americans, and a system that was largely willing just to ignore them and take the administration's word for it, when they've had their day in court, a significant number have prevailed and the government's lost. And I believe, and correct me if I'm wrong, there are 8 cases currently pending at the Supreme Court.
Those are appeals.
Some, I don't know if it's 8,
Yeah.
but there's certainly some.
I mean, what we had for a number of years was an executive branch that was drunk on a thirst for power, a legislative branch that was too cowardly to fulfill its role in our system of checks and balances, and a judiciary that, when push came to shove, stood up and said the rule of law is not some quaint theoretical concept that we apply when it's convenient. And it's fortunate that the courts had the guts to stand up and do that. Guantanamo was not, as some people believe, beyond the reach of the law. I mean, that was why it was selected, to avoid the law. Military commissions were not, as some people believe, fast and easy. They've been anything but. You know, it's been 9+ years since President Bush signed the order authorizing military commissions. We've completed a grand total of 5 trials. 2 of those trials, Hamdan and Hicks, received what by most standards would be considered misdemeanor punishments. They're both convicted war criminals, but they're both free men back in their home countries, where another 171 men are still at Guantanamo. That was one of the jokes that we used to make about Guantanamo. In order to win, you got to lose. You got to go to court and be convicted as a war criminal, and you might have a shot at going home. But if you don't get your day in court and you don't get convicted, then you may stay there forever. Of the nearly 800 men that were ever detained at Guantanamo over the past 9 years, as Andy said, there's still 173 that remain there. At this point in time, I don't think the question is what could we do in these circumstances. After 9 years of failure, the question is what should we do? I think our reputation has been tarnished by what we've done at Guantanamo Bay. I don't know if you noticed, Secretary of State Clinton criticized the Russians, the Yukos oil executive that was prosecuted a second time. I don't know how we stand up with a straight face and criticize others as long as we keep Guantanamo Bay open and people detained without ever setting foot in a courtroom. I think part of restoring our reputation means we stop ignoring that we tortured people. The Obama administration came in with a lot of lofty rhetoric about what it was going to do about Guantanamo. I saw today where Secretary of State Clinton in Yemen said President Obama is absolutely serious about closing Guantanamo. I don't know why he's absolutely serious now, and maybe he was just serious in 2009, but the fact remains Guantanamo is still open, and there doesn't appear to be any end in sight. As I said, I think one thing we need to do to restore our reputation is to confront the fact that we engaged in torture. There have been 5 different judges that I know of, military and civilian, that have concluded that detainees were tortured. You've had a number of government officials, and not liberal officials, Bush administration officials. Susan Crawford was the convening authority for the military commissions when I resigned. In January of 2009, about a week before President Bush left office, in an interview with Bob Woodward in the Washington Post, Ms. Crawford explained why she didn't refer the case of Mohammed al-Qahtani to trial. Ms. Crawford, who had been Dick Cheney's Inspector General at the Defense Department, said, "We tortured al-Qahtani." The Convention Against Torture, the Torture Statute, and the War Crimes Act say that we have a duty to investigate and prosecute allegations of torture. But for some reason, we just ignore that obligation. It doesn't say if it's convenient or when you get around to it, you do it. It says you have a duty to do it. And I think we're being hypocrites as long as we continue to ignore the fact that we engaged in torture. It's been interesting lately. If you saw, there's an interview with John Yoo not too long ago where he said, hey, look, I was just a lawyer. I was asked to provide advice on a range of options, and I provided an opinion. I wasn't the decision maker. If you saw the interview with President Bush here recently, he said, hey, look, I'm not a lawyer. I'm just the decision maker. They laid out the options. So you've got plausible deniability where nobody's accountable and nobody's responsible. And this is America. That's not the way we operate. We need to restore our reputation. We need to do the right thing. And as long as Guantanamo is open, we're not there.